Good morning, I'm Gary DeWaal, and this is Bridging the Week for April 8th through 12th, and today is April 15th, 2019. The New York State Department of Financial Services canceled the temporary authority of a major cryptocurrency exchange to operate in New York, saying it does not qualify for a BIT license or a money transmitter license for not meeting anti-money laundering, AML compliance officer quality, and capital requirements. The firm now has less than 60 days to liquidate or offload its existing New York customers. Separately, a mistrial was declared in the criminal action against the alleged programmer of the purported flash crash Spoofer in connection with 2 counts of aiding and abetting spoofing. Today is tax day in the United States, so I may hurry home to experience the joy of finalize my sorting out pages and pages of records and government forms for the privilege of paying my taxes. Let's get started. The New York State Department of Financial Services revoked the authority of Bittrex Inc. to operate a virtual currency business involving New York or a New York resident effective April 11th, 2019. The firm had been conducting business in New York pursuant to a safe harbor granted by the New York Department of Financial Services while its license for a New York BIT license was pending since August 10, 2015, and for a New York money transmitter license since July 27, 2018. New York Department of Financial Services denied Bitrex's license and revoked its authority to conduct a virtual currency business in New York, saying the firm could not, quote, demonstrate it will conduct its business honestly, fairly, equitably, carefully, and efficiently, end of quote, as required by applicable law and rules. In response, Bittrex issued a written statement saying it was, quote, saddened and disappointed by New York Department of Financial Services action. As you may remember, under New York law and rules, persons engaging in a virtual currency business involving New York or New York persons must typically have a New York BIT license and a money transmitter license unless exempt. The BIT license requirement was adopted in 2015. According to the Department of Financial Services, Bitrex's current anti-money laundering and economic sanctions compliance program was inadequate. It was not certain that Bittrex followed its own guidelines in approving digital tokens for trading on its platform, and Bittrex would not commit to comply with the Department of Financial Services capital requirements. In connection with the firm's AML program, the Department of Financial Services indicated that Bittrex lacked adequate policy and procedures, may not have employed an AML compliance officer with adequate experience and appropriate level of authority and effectiveness, did not adequately train employees, and may not have had adequate independent testing of its AML program, all as required. Bittrex generally disputed New York Department of Financial Services findings, although acknowledged that it was on a current, quote, journey to improving and maturing our compliance function, end of quote. The firm noted that, quote, corporate responsibility is in our DNA, and our commitment to regulatory and compliance guidelines is second to none, end of quote. Under the Department of Financial Services order, in addition to suspending its New York business by last week, Bittrex was required to wind down or transfer existing positions of New York residents by June 9th, 2019. I'm not sure what's really going on from reading both the Department of Financial Services and Bittrex's public statements, and it may well be that the Department of Financial Service was justified in its bottom line determination. However, the public manner in which Department of Financial Services exorciated Bittrex seems inappropriate. For more of my thoughts, see my commentary entitled Memory Lane and My View in the article version of this vlog at www.bridgingtheweek.com. And finally, a mistrial was declared by the judge presiding over the criminal trial of Jitesh Thacker, the alleged programmer of software used by purported flash crash spoofer Navinda Sarao. The declaration followed the failure of the jury hearing the case to reach a unanimous verdict. The jury voted 10-2 in favor of acquitting Mr. Thacker of 2 counts of aiding and abetting spoofing. Previously, the judge hearing this case acquitted Mr. Thacker of the criminal charge of conspiracy to commit spoofing. The judge instructed the Department of Justice to determine whether it wanted to proceed with another trial of Mr. Thacker or forego prosecution within 2 weeks. Frankly, the outcome of a hung jury in this case was surprising, but the failure of 10 jurors to vote for Mr. Thacker's conviction for aiding and abetting Mr. Sarao's spoofing is significant. Clearly for them, the GOG did not provide sufficient proof beyond a reasonable doubt that Mr. Thacker programmed software with the knowledge that Mr. Sarao intended to use such software for illicit spoofing purposes. Given the apparent weakness of the Department of Justice's evidence and the challenge of flipping 10 jurors, it seems an inappropriate use of the public purse to retry Mr. Thacker. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out, www.bridgingtheweek.com. I'm Gary DeWaal. Have a great week. Do your taxes. And until the next edition of Bridging the Week, ciao.